This is the next session. This session is on involving global legal perspectives with respect to computer related inventions, CRI, EU, India, Japan, USA, etc. Ladies and gentlemen, we are ready to commence the next session. May I invite our distinguished chairpersons, Mr. Pravin Anand, Managing Partner Anand and Anand, to kindly join us on the stage, on the panel, and inviting our chairperson, Mr. Grant Philpott, Principal Director and Chief Operating Officer, ICT EPO, to kindly join us on the dais, please. May I also invite our eminent speakers, Mr. Georg Weber, who is Director ICT EPO, Mr. Sushil Satpure, Director DIPP, Professor N.K. Goyal, President CMAI Association of India, Ms. Teresia Fredriksson, she's Senior Patent Attorney, Ericsson, and Mr. B.P. Singh, Deputy Controller of Patents and Designs, IPO. Ladies and gentlemen, please put your hands together to welcome our distinguished panel on the stage for the second panel discussion session. Once again requesting for all mobile phones to be put on to silent mode and the exit doors to be closed, please. Namaskar and good afternoon. Distinguished chairpersons, Mr. Pravin Anand, Managing Partner Anand and Anand, Mr. Grant Philpott, Principal Director and Chief Operating Officer, ICT EPO, eminent speakers on the panel, distinguished delegates, ladies and gentlemen. I once again warmly welcome you all to the second panel discussion session of today's conference. The topic for this session is panel discussion on involving global legal perspectives with respect to computer related inventions, CRI, EU, India, Japan, USA, etc. And the time duration for this session is approximately 1 hour 30 minutes. But before I hand over to the chairpersons, a quick round of introductions. Our chair, Mr. Pravin Anand, is the managing partner of Anand and Anand Advocates, intellectual property law firm. Mr. Anand's areas of specialty include intellectual property, litigation and dispute resolution, and IP strategy.
These days, all you need is a one-line introduction for every speaker.
Okay,
That's
sir.
what we're going to follow. We'll keep it short.
Sure, sir.
There will be more discussion.
Sure, sir. As you say, the chairperson, Mr. Grant Philpott, is the Chief Operating Officer, ICT European Patent Office. And with those words, I hand over to the chairpersons to carry forward the proceedings of this session. Over to you, sirs. Thank you.
It's a bit tight on the table. I hope.
Tight also on the stomach after
Yes. So apart from your belts, don't fasten them, you can loosen them. Just bear with me, you might not have enough elbow space. And I'm not commenting on the Indian patent system. Right. So these days, artificial intelligence and deep learning and Internet of Things and Industry 4.0 and autonomous cars and drones and robotics and data analytics and design thinking and MOOC and the cloud, and all these are phrases which all of us are reading about on virtually on a day-to-day basis, and they become the buzzwords of today. So much so that people are saying that this revolution is changing humankind. So I'd like to mention Mr. Klaus Schwab, who is the founder and executive chairman of the World Economic Forum, who in a recent book said that we cannot be caught in linear, traditional, and non-disruptive thinking. It was very important. I just picked up one word, one sentence. This is precisely the linear, traditional, and non-disruptive technologies seem to be, I can't say out of the window, but certainly require major rethinking. This revolution is characterized by speed, exponential growth. The velocity, the breadth and depth is transforming systems as a whole and also transforming who we are as persons. I'd like to quote a gentleman who's written fantastic books on, the first book was called Sapien, and the next book is called Homo Deus. Yuval Noah Harari is an Israeli writer, and according to his entire theory, very well researched, books worth buying and reading, he says the plague, famine, and war. By plague he means disease. By famine he means food problem and war. Man seems to have already conquered these. Today people don't die of food. They die of fatty food. They don't die of wars. They die of terrorism, which is war of a different kind, but not classical war where one king's armies fight another king's armies. He seems to say that the focus is now changed to man trying to become immortal. He wants to live for 150 years, or maybe even longer. And I believe Google has started a project on that. And happiness. He seems to want happiness. The heart of all this transformation which is happening is software and digital technologies. And that's very interesting because when we talk of computer implemented inventions or computer related inventions, they are bound to grow in this new environment. You will have, by 2020, today there are 18 billion, there will be 50 billion devices, which is 7 times the population of the world. At that time, 7 times the population in 2020. So you can see how there will be so much more filings of software or computer implemented inventions. So the first problem which I'd like to put to the panel and those of you who might fit it into their pre-prepared speeches is the filing in India, the low filing in India. So when we talk of filing, they say we are the 7th largest filing country in terms of patents. That's true, but then should we be comparing ourselves to China? Some people think that that's the correct comparison, in which case we are abysmally low, about 45,000 patents every year as compared to more than a million innovation patents. And we've got solutions which have started, Digital India kind of projects and Startup India kind of projects, and of course amendments made to the patent rules, amendments made to, the introduction of the IPR policy, which gives impetus to startups, tax benefits and filing benefits, lower filing fee, facilitators, and out-of-turn examination and so on and so forth. And those are bound to increase. But this morning, I was in a meeting when somebody mentioned a project which was done by their company, where they found that there were 9 states in India which was affected by the Naxalite terrorists. And those states had a major communication problem, as power lines were cut and roads were blocked, because of which there was such a problem that they had to find appropriate communication technology for rural India, and that to terrorist hit rural India. And they spent 4,500 crore rupees. So I asked them, did you find the solutions? They said, yes, of course we did. Did you apply for patents? Yes, we did. How many? 2. That is a problem. So therefore, autonomous mobile stations is a known technology. Question is, 2 patents. That appears to be, it reminds me of the days of the Simputer, when no patents were applied for the Simputer, so they got sued for a violation overseas, and they were unable to employ a lawyer overseas because the lawyer's fees appeared to them to be like damages. And they said that's too high, and they gave up the project because they hadn't applied for patents. So first problem appears to be, now what is the result of low filing? The mass of cases, cases that go up to the high courts, that go up to the Supreme Court are so low that there are no decisions, and the principles are not refined. They don't become sophisticated like they've become in trademarks and copyrights. They become highly sophisticated. You can compare Indian trademark law with the law in the United States, and a lot of commentators, not Indian, neutral, have said Indian well-known trademark law is stronger than the US law, when they didn't protect Bukhara, and we protected a lot of on the basis of trans-border reputation, a lot of well-known trademarks in this country, with very, very little evidence of spillover. But the point here being, when you look at patents, that growth hasn't occurred because cases have not gone up. Cases have not gone up because people have not filed patents. That's one area of a problem. The second issue I would look at is the degree of protection. And we have Mr. B.P. Singh here, who I would probably request to come last so that he can hear the problems of Mr. Goyal and Teresia, both of whom are from the industry, and they will point to the kind of problems that they are facing. And Mr. B.P. Singh at the end will come and give us the Indian perspective of the Act, particularly the guidelines, how per se came to be added, what is the impact of that, the role of technical effect, what is the meaning of that, guidelines before February 2016, between 2016 and June 2017, and post-June 2017, what are the changes, and recently, what is the law? Novel requirement, novel hardware no longer being in the guidelines, what is the current state of the law? So I would hope that he can clarify on that. The interaction between computer software and hardware, what kind of interaction there needs to be, all of this will also be covered, hopefully, by him. Ownership issues are another issues which are quite hot, where I'm reminded of a project started by Microsoft and ING banking group and J. Walter Thompson, when they took 346 paintings of Rembrandt and they developed a program which saw those paintings, analyzed them, artificial intelligence, and then made a painting called Next Rembrandt, which consists of 148 pixels, capturing what Rembrandt's in his paintings, what the lips look like, what the eyes look like, etc. And the question then would be, who is the author of that program? And a lot of people are writing that Indian Copyright Act has a solution, because the Indian Copyright Act says that the person responsible, not the person who wrote the program, because that would be like giving authorship to the manufacturer of pens for all the books that were written with that pen, but instead the person responsible, like in a film, the person responsible for bringing together all the talents and producing. And that could be a good solution even for patents. I'd like my European experts to tell us a little about ownership issues. Speed, I'd like to just mention, the speed of enforcement is becoming a huge issue in India as the Commercial Courts Act has come into force. And it has changed everything. There is a timeline within which you must finish the lawsuit. Roughly translates to 1.5 years. 1.5 years from beginning to end, a lawsuit would be finished. Should I say it again? It's something, please believe it or not. But that's the truth. E-courts, the courts have become e-courts. You have video conferencing for if a witness is unable to make it to India. You have admission of electronic evidence. Emails and all are read in court every day. You have local commissioners who collect evidence. And you have summary trials where if a defendant does not make a good point, the court at the stage of framing of issues, which is just 3 months down from date of institution, can dismiss the suit or decree it in favor of the plaintiff, depending on which way the balance is. So speed has really started in a big way. Let us see if we can have the same speed in the Patent Office. There are some important changes that have been made, which are very, very significant. Some promises have been made, and we will have to see over the years how they pan out. We have to also see if the model of the Delhi High Court, which is a good IP court, can be applied to the 23 other high courts in the country. Then remedies. Remedies, building up a damages culture appears to be a very important deterrence step that needs to be taken. And of late, there have been positive decisions, there have been a few negative, and on the balance, very positive changes made in India. On the legislative role, just a thought, to what extent are courts responsible for legislative changes, or is their role confined to interpretation and the doctrine of equivalence? Kind of by that, could they expand, and maybe Mr. Weber and Mr. Philpott could add value on explaining that and the way we are likely to go. So with that, let me now start the session. I'd request my co-chair, Mr. Grant Philpott, to say a few words.
Thank you very much, Pravin. You have covered the aspects of this panel discussion so well. I really only have one thing to add. We have heard about what we are dealing with. I would just make a reference to how we are dealing with it. We are working within a patent system that was developed largely in the 1850s and has not changed an enormous amount since then and would still be recognizable to the founding fathers. It was a system established, of course, for hardware innovation. We now live in an era which is becoming substantially software innovation. And I think this would be the only additional aspect which I would add to this panel discussion for consideration, and it would be interesting to hear the views of the panel on that if it's relevant to their particular intervention or for questions from the floor. Thank you very much.
Thanks, Grant. May I request Mr. Goyal to give us the industry perspective? Try not make it too vitriolic, not too acidic. Although I think some of the points he's going to raise will be good and well answered by the others on the panel.
I'm not sure if whatever I am going to say, I'm allowed to say or not, and people will like it or not. But because you have given mic to me, so I have the liberty to share something. So, first of all, I am known in the IPR world as an odd man out. That is the first thing I have. All experience, all views I share primarily relate to mobile telecom sectors. I will start by compliments to DIPP, MITY, EPO, EBTC for the wonderful program, especially for DIPP for the way they have done the liberalization and they have made India proud of being up in the age of doing business. I am very happy to be on this panel for the first time with 3 experts from the globe, Mr. Grant, Mr. Georg and Ms. Teresia. I am particularly happy to see Mr. Anand here because I am going to quote some of the statement he made in December. So that is a wonderful opportunity for me. And of course, Mr. Satputta and BP Singh, Deputy Control Director, are here. Thank you very much. Before I come, I am also very happy to see the topic of the session, which is called Creating Robust IPR System for ICT for 21st Century. Yes, we should have that. And as was just now said by Mr. Grant, because the laws were made in 1850, are we geared for 21st century is the first thing. That is the first thing we have. Now, we all agree, without any doubt, without reservation, IPRs must be honored, must be respected, must be protected, they must be paid. All innovations in the world should be protected and they need to be paid so that they recover the cost, quote unquote, reasonable basis. Dichotomy starts from here. We want to pay. I am willing to concede on behalf of industry, we can pay 50% royalty, 100% royalty, 500% royalty, 1000% royalty. But we don't want to enter into unknown territory. The problem we face today is there is nobody on the earth which says us, okay, Mr. Industry, you want to start manufacturing of this item, these are the patents to be followed by you, these are the royalty you have to pay. Because then I will have the business plan. If I find viable, I will go ahead, otherwise I will not go ahead. But that I am not given the liberty. That is the first problem we face. While we have EPO here, a wonderful office catering to around 57 countries with a staff strength of 7,000 people. In India, we hardly have around 700 people with us. Can you help for this thing? Can you think of some solution? Otherwise, what happens when we start the production, we know nothing of the IPR. Then suddenly somebody will come, hey, I have this IPR, I have this IPR, I have this IPR. So this goes on. We don't know how many come. In the morning it was said by Mr. Darbari, there are 400 patents on a smartphone. My problem is 400 confirmed or 401 or 405? If yes, how much is the royalty payable? That is the first thing. Second part comes up. The usual problem, we say FRANT. Does FRANT has a legal backup somewhere? Based on reasonable basis, what is reasonable? A IPR was done around 5 years back or 6 years back. It is valid now for more 5, 10, 6, 20 years. The volume business has increased. So what is reasonable? And because of NDA, there is no information available as to what has been paid by somebody else. Next point comes the SEP. Wonderful concept, SEP. I don't want to go into figures to avoid time, but there are lakhs of SEPs which people claim. Are they really SEP? Has somebody said this is SEP? In most of the court cases in the globe, cases are decided out of the court. So we don't know whether SEP exists here or not. Another point comes up in terms of royalty. Somebody has a IPR on my phone only for a chip which I hear in the ear. I purchase this for $1 and the cost of phone is $1,000. I pay royalty on $1,000. Is it justified? I do not know. All the legal experts, they have a set rules, set judgments in the world, primarily for medical. In the tablet, you can't differentiate between one and other. This is the problem we are facing. Another problem we face, primarily we are importing components from world-known companies. I don't name them, but world-known companies. Every company is multi-billion-dollar company in the world. They follow the IPR, they pay the royalties or so. Now, when I make a system out of that, I'm just assembling it. Am I required to pay royalty or that company who has given me the supplies? These are the prima facie issues we face in the industry, which troubles us. Coupled with that, the last point, a type of situation where we have very good experts in the world, they are fighting cases every day. There are 4 or 5 companies in every country, they are fighting against each other. And when we talk of India, we hardly have any experience of those things. In one case, this is the decision, other case, this is the decision. Where to go? Are we prepared in India, I'm talking India only now, as a startup, as an innovator, can he face the legal slot? All my companies are terrified when they receive a letter from somebody. The letter comes, we have X number of patents, 3,000 or 200 or 5,000 SEPs. Please pay us the royalty. We do not know how many of them registered in India, how many are not. I'll close it now here. Thank you.
Thank you very much, Mr. Goyal. That was an excellent, thought-provoking speech with issues which are being raised in our courts and in a lot of the mediations that are going on relating to telecom. And these are the very issues that are being discussed. And I'm sure we'll be able to get into a discussion in the question-answer session and have clear answers to these. Teresia, may I request you now to give us Ericsson's viewpoint?
Thank you. And I have to thank you for inviting me here and making it possible for me to take part in these discussions in this panel. And I would firstly like to congratulate the DIPP and the IPO for the excellent job on the patent system. They've managed to achieve something in about a decade that has taken any Western country 100 years to achieve. So that is a well-deserved result. Well done. I work for Ericsson, which is, I'm sure some of you know. We no longer make mobile phones, but we make base stations. In a way, to go back to the gorilla we had earlier, we are the providers of the highway for the truck of gorillas. We're the ones that makes it possible for the truck to travel as fast as it does. Otherwise, it would be having to go cross country, and it would be much harder, which might be a good thing for some, but. Ericsson is a multinational company but we are also very solidly grounded in India. We've been in India for over 100 years. We have 25,000 employees in India, which is more than we have in Sweden. We have inventors that are Indian. We have about 2,500 applications where we have Indian inventors taking part. We heavily reinvest in R&D about 5 billion a year. We do get money from licensing, but that's about 2% of the turnover. So 90% and more is from services and manufacture of hardware. The issues that we are here to just discuss today, and that's been touched upon by several in the earlier panel and here as well, that when it comes to computer-related inventions, we are discussing a creature that is evolving in a system, an IPR system, which was designed for something that didn't even know there would be computers, that he didn't know there would be software. So the system is more applicable to mechanics, hardwares, things you can touch upon, that you can see. But the computer-related inventions are here to say it is in every field of technology. They are there. In my field of telecom, we started out with having female operators managing the connectivity between telephones and manually changing the phone calls and establishing connections. We moved to mechanical switches, and now everything is digital. The effect is the same. The technical impact of the ideas is the same. It's a connectivity. It's a clear effect of the inventions. Another area where is automotive anti-collision systems. They do tend to appear in software, but they have a very definite impact on all our lives. Let's see. So the computer-related inventions are here. We need to take care of them. We need to be able to protect them. We need to enable applicant or inventors or companies a fair return on investment in order for them to be able to reinvest in further development and technology. When it comes to being a multinational company, we have the issue of a legal system which is territorial. It's meant to be country by country, but all companies are becoming more multinational. We are global. It's easy for a single company to reach on a global scale, which wasn't possible earlier. So we need to have a system where it is a company has a reasonable similar treatment of their inventions, even if you move from one country to the other. It doesn't necessarily have to be identical or the same, because there are differences in legal systems, there are differences in culture, but to have an idea that the way I write this application, the way I formulate my claims will be treated somewhat similarly if I go to US, if I go to Japan, if I go to India. So it is a matter, not protecting, if we go back to the per se vocab, that protecting software as such, but protecting technical innovations that are software driven or contain software, which is something we need to take care of in all jurisdictions. And on a final note, I would say that Ericsson is, as other countries, we have a heavy R&D. We invest in R&D. We also invest in our IPR. We recently filed a patent application with more than 130 inventors. It was a huge effort concerning 5G. And I think it shows that we want to invest in the system. We believe in the system, but we need to work together to get it to really, really work for everyone, from the big multinational companies that I represent to the small and medium-sized enterprises that don't have the legal capacity or the financial capacity to function all over the world in the way that big companies can. And I think that's about it for me. Thank you.
Thank you, Teresia. Now I'd like to invite Mr. Satpute, Director, DIPP, and before I do that, I'd like to congratulate him and his department for having done a splendid job of transforming the IP landscape of this country in the last few years. Of course, there are important steps and areas which require changes, some quite major. Maybe we'd like to hear from him what his department feels are areas that they need to continue to do the good work in. Mr. Satpute.
Thank you, Mr. Anand. Before I start speaking on the initiatives taken by the government in the field of changing the IP landscape and the administration of IP offices in the country, I feel that sessions like this brings users as well as providers at one platform, and the communication gap between the users and providers should lessen by more interacting with each other. That may help attending to each other's problem. When we talk about the changes that we have done in recent past, I must talk about the National IPR policy. The National IPR policy in its vision statement states that an India where creativity and innovation are stimulated by intellectual property for the benefit of all, an India where intellectual property promotes advancement in science and technology. I repeat this word, advancement in science and technology, arts and culture, traditional knowledge and biodiversity resources. An India where knowledge is the main driver of development and knowledge owned is transformed into knowledge shared. With this vision statement, IPR policy further developed its own objectives which are related to today's session. The objective head generation of IPRs in its 2.28 clause says that IPR generation of ICT technologies, including those relating to cyber security for India, will be encouraged. It also says in 2.29 that takes steps to increase domestic filings of patent applications. A related objective that is of our concern is under the head legal and legislative framework. It says review and update IP related rules, guidelines, procedures, practices for clarity, simplification, streamlining, transparency and time-bound processes in administration and enforcement of IP rights. Now with this background, let me just go back to talk about the Patent Act 1970, which in its section 21J defines invention, means a new product or process involving an inventive step and capable of industrial application. There is a definition of inventive step also, which talks about technical advance. The chapter 2 of Patent Acts has special significance as it enumerates inventions not patentable. Section 3 of the chapter, what are not inventions, states in its subsection K, the most known section to this audience, section 3K, a computer program per se is not an invention. This particular chapter not only talks about what are not inventions, it also talks about inventions that are not patentable, and this section is there in section 4 of the Patent Act, and it relates to the atomic energy sector. Now this is repeated from Act to bring out the fact that there are certain categories in Act that are not considered to be inventions at all, and the other category wherein inventions pertaining to certain area, that is atomic energy, are not patentable. This point is highlighted to understand the issues related to computer related inventions, wherein applications may involve claims related to computer program either in isolation or otherwise. In order to bring more clarity regarding the processing of such applications by Indian Patent Office, guidelines on computer related inventions were released in 2015. It is a known fact that the introduction of these guidelines invoked mixed reactions, and thereafter, in an attempt to better address the issues involved, a revised guideline was issued in 2016 as well. While 2015 guidelines were attempted to make applicants, stakeholders, examiners aware that mere presence of computer program may not be a reason to attract Section 3K, the revised 2016 guidelines expressed it in another way by making presence of novel hardware a mandatory condition for being considered as invention. This again triggered series of representations from all the corners of the industry. A committee was formed by the government, and committee preferred to recommend to the examiners of IPO after discussing with the stakeholders that the legislative intent behind the attachment of the suffix per se to computer program, which is evident by following views expressed by the Joint Parliamentary Committee while introducing Patent Amendment Act 2002. The JPC said that in the proposed clause 3K, the words per se have been inserted. This change has been proposed because sometimes computer programs may include certain other things ancillary thereto and developed thereon. The intention is not to reject them for grant of patent if they are inventions. However, the computer programs as such are not intended to be granted patents, and this amendment has been proposed to clarify the purpose. Now here, Section 3K has gained a shape, and the law is applicable in the form of 3K, and whenever patent applications are submitted to the Indian Patent Office, they are being evaluated from the point of view of 3K. The term novel hardware was recommended to be deleted in 2016 guideline by the committee, which was requirement as per the second guidelines released in 2016. At the same time, it was also recommended not to have any further adjectives or indicators regarding technological advance, which was produced in 2015 guidelines. Both the recommendations have been accepted by central government, and the guidelines have been released in July 2017. Most of the audience that we have here, we have interacted with each other when we were dealing with this matter, and I must say it was a kind of consultative process. A stakeholder concerns were noted at each and every point. The suggestions or recommendations made by the executive committee was revised after discussions with the stakeholders, and now what we have is a position that was recorded by Joint Parliamentary Committee before introducing Section 3K in the Act. Now with this background, I'll leave the further discussion on the technical aspects of how to examine the application to Mr. BP Singh. Mr. Anand, if you can now hand it over to him.
So we have to toss a coin now on whether Mr. Singh will go first or whether Mr. Weber will go first. So we hadn't decided. Would you wrap up at the end? Mr. Weber.
Thank you. Thank you very much. We heard several things about the patent system and whether they are in time or outdated by now. We learned of two very interesting cases which have to do with timeliness and good preparation before you do an investment from Mr. Anand and Mr. Goyal. I would like to briefly give a view about those things. First, a patent office, every patent office is not doing its own law. It's an association which administers and executes a law given by a governmental body to him. This should be very clear. So patent offices are not responsible for a certain kind of law. What patent offices are doing, they look very careful at the case law and evaluate of how the given law has to be interpreted in the light of case law of an independent juridical body given to them. Many patent offices use these results of the case law in order to amend and adapt their guidelines. Being in some emerging and fast-growing technologies on time with that, is of course essential for everybody in a patent and a legal system. For instance, the EPO is now annually revising and checking up his guidelines for computer implemented invention areas in order not to miss important changes in the interpretation of a law, given at a time where those technologies were not known as such or to that extent they are now available. Nevertheless, by doing that, we cannot deviate from the given law as such, and it will not be the role of the Patent Office to fill a perceived legal gap if there is any. We have stressed a lot the expression as such already today, and as such has not given only a lot of work to lawyers, but also a lot of work to patent offices in the past years. When I look at the as such as given to the European Patent Convention, I'm personally sometimes amazed how forward-thinking the fathers of the EPO must have been